Hello, everybody. Welcome back to another lovely day. And we are here to host the second webinar on behalf of Kurzfeld Law. And we have had some tremendous response from the previous webinar. So we want to continue, keep up with the momentum, and share with you exciting insights, analytics about immigration and immigration, especially focused on Canada. And so today we have yet another webinar, an informative one, a very pertinent and a very relevant one for today's context in terms of Canadian immigration. So we are here to discuss a number of topics, subjects in relation to refusals and rejections when it comes to Canadian visa applications. So there's a lot of context to this. Canadian immigration, as we all know, has been quite unstable for the past few months. We know that there has been a lot of delay in terms of application processing, and in the meantime there has been a very high number of refusals that have been handed over by Canada, right? IRCC basically. So we are here to discuss with our guest today, Mr. Ronen Kurzfeld. So we are here to discuss with him about what is this refusal all about. We all know that over the past few months, just as much as there has been an increase in the number of applications, there has also been a number of increase refusals that are given by uh, IRCC Canada. So we are here to discuss with Ronan Kurzfeld um, what these refusals mean and what are the next action steps that someone has to take if they face refusal in terms of a Canadian visa application. So let me take him on board here. Hi, Ronen.
Hi Umar, how you doing?
I'm doing great. How about you?
Great. It's a long weekend. Everybody's in a good mood.
Right, that's absolutely nice. So just let me introduce you to the audience before we go into the questions and talk about more details in relation to immigration itself. So Ronen, as you might have known, has dedicated his law career and practice exclusively to the area of Canadian immigration law, and he's a member in good standing of the Law Society of Canada and the Canadian Bar Association Citizenship and Immigration section. Ronen was interviewed by several leading media outlets in Canada, and he has also been invited by Service Canada to provide opinions and comments about certain work permit programs. So we presume that Ronen comes from a very intellectual background, and he has the authority to share information about Canadian immigration and subjects in relation to immigration generally. So let's go straight to the questions and see how we can explore uh, some of these thoughts, some of the thoughts people have with regards to Canada and Canada immigration and refusals itself. So, Ronan, I would like to ask you the first question. Comparing pre-COVID statistics, we observe that there has been a steep increase in terms of the rates of refusals. Do you have any specific reason as to why there has been an increase in the refusals?
So there are probably a couple reasons that explain why there's an increase in refusals. Number one, Canada started using an AI intelligence system called Chinook that essentially triages and pretty much decides on an application within maybe 10 to 12 minutes. So that's number one. Number two, and that's related to number one, is that, as you mentioned, Umar, there's a very high volume of applications that those officers have to decide upon. So, what happens essentially is that they have about 10 to 12 minutes really to decide an application. Now, if the internet is slow at the visa post, it frustrates too. It can even be longer. So, that's why Canada started implementing that system. And that Chinook system sometimes, and we've seen it through court cases, doesn't review all the documents that are submitted as well. So obviously it's a very sophisticated system, but there's always a human element required. And I think those two combined, they led to increased number of refusals.
The main reason is because of the volume of applications, like you said, and in the meantime this adoption of a new AI based system which is causing
Co-
the kind of issues that we
Correct.
have right now.
And if you can always add, in all due respect to everybody, some applications are very poorly prepared. Just as simple
Hmm.
as that. So I
Right,
would say there are
right.
three reasons. If it's a poorly prepared application, the Chinook that doesn't help, Some cases it helps, but most cases not. And of course, it's a huge backlog and volume that they're handling.
Right. So many people panic, when they get a refusal. They think that it's the end of the road, and that's it. They have to completely forget Canada and stuff like that. Should it be the case? Should people panic about refusal, or do they still have a chance to kind of come back and still pursue the dream to move to Canada, or maybe visit or whatever?
And that's a very valid point. I always say, to the lawyers in the firm, remember when somebody calls us with a refused application and we're dealing with federal court and litigation, we always, for the first 30 minutes of the consultation, we're not psychologists, but we act as psychologists because people panic,
Right.
they're upset, they're angry, they're confused. It's a mix of emotions. And I always tell them, and we tell them, not just me, to put things in perspective. That's number one. Okay, life is bigger than any application, but there are solutions, there are ways about it. And we always try to say, like, people take it personally. It's like they're not, something is wrong with them. Okay, and it's not. All right, so it's a decision, there are ways to deal with it. But we always say the last thing you should do is put yourself in the head of an immigration officer, because you'll never get out of it. So there are options, okay, and depending on the case, and whoever gets refused and whoever takes those cases has to do a very thorough analysis of what's next. Can it be federal court, just the litigation, sometimes reconsideration, sometimes just refiling, right? I can tell you with reconsideration, that usually in our experience, unless it's something very clear cut, usually they don't work. And many times those officers, the visa posts don't get back to the applicants. So people even get more upset. But that's number one. But usually, what we do, we always, when we get retained, we file the notice of appeal, and we'll talk about the process, I'm sure, later. And after we file the notice of appeal, we get the reasons from the Department of Justice, and then we can start making decisions whether to perfect records or to refile.
Right, brilliant. So, what are the available options for people with refusals? What's the immediate next step? So, see, the thing is, sometimes law is complicated as we understand it. So, what do you think should be the first immediate
No,
step somebody could take
you're right.
when they
So
get
first
refused?
of all, depending on the type of refusal,
Hmm.
contact a lawyer right away, because there's a deadline to file appeals. Typically, if it's the refusal is for an overseas decision, it's 60 days to file the notice of appeal and stop the clock. If it's an inland refusal, then they have 15 days. And people get confused. We get calls, people, oh, we know it's 60 days, but the refusal was inland and now it's too late. Of course, we can file motions to, anyways, but we don't want to get into that. You want to be on time. So that's a first step. Contact the lawyer right away. And remember, only lawyers can represent in court. Paralegals and consultants cannot. So please contact the lawyer right away. Once the application, once the lawyer gets a file, then the analysis starts. And the way we do it, we typically, depending on what we see, you want to stop that clock, okay, unless there's a reason or a very clear reason in the analysis that we say, you know what, court is not going to work in this case for whatever reason, whether the application was poorly made or other reasons. And then we may either discuss getting the notes, so applying for the case notes, and then refiling, sometimes reconsideration. But usually I always try to keep things simple. It's reconsideration, refiling, and appeal, and not necessarily in that order. Okay, we usually use the notice of appeal to get the notes, and then we decide whether it's worth it to proceed with the court case or just to refile.
Oh, that's
But
nice.
please
So,
call somebody right away, call a lawyer right away, because the clock is ticking.
exactly. So that's something very important. I think that you stated that many people do not know, like when they get a refusal, how long do they have in terms of time to kind of take the next course of action. So it's very important. Uh, Whoever is listening, if you have faced refusals and if you want to kind of still pursue that application, you have just 60 days if you're an applicant from outside Canada, and if you're an inland application, you just have 15 days. So be sure that you contact a
Yes,
lawyer as soon as
and
possible.
just sorry to interrupt. It's really not where the person is, where the applicant. It's the type of application and where the decision came from.
Exactly. So
So
that's
somebody
kind of.
can presumably file inland, leave Canada, they get refused, they don't get 60 days. If the decision is an inland decision, it'll be 15 days.
Oh, right. Yeah, that makes sense a lot. So, is a refusal really considered a stain for any future application to the IRCC? That's something that a lot of people have. See, if they get refused and they lapse the time. Say you finished 60 days and you could not appeal or do anything about it, and then they want to leave some time and maybe try again. Do you think it's a stain, that refusal that had occurred is a stain?
So that's a question everybody is asking us. So the reality, and I don't want to sugarcoat, I would not call it a stain, but it's definitely the record is there. So it's not something that gets off the record or disappears after some prescribed amount of time. That will always be there. And I always say immigration is about people. The clients are people, the officers are human beings, everybody's a human being. And when you refile another application, always remember it's pretty much you telling them, maybe not in a direct way, that look, you guys made a mistake or your colleague made a mistake, come and fix it. Okay, so it's not a stain. There are definitely ways about it, even on refiling sometimes, if it warrants refiling. But the record is there, and we always address the concerns, right? So even if it's a refiling, you have to address the concerns of the visa post. And I can give you a very recent story. We had a client from India, a student, and he had 7 student visa refusals over a span of 3 years. His brother contacted us. We refiled. I told him, listen, I'm not too optimistic, but the strategy will do a very strong case. And if they refuse, we'll go to court after. And we got approved on the refiling. Like obviously it was beyond the time to appeal. But we had the notes for all the files. And with the notes, that's how we can address the concerns. So you must address the concerns of the officer.
That's great. There is definitely chances, and we can definitely hope that something will come out right in the future, because it's all in the hands of the IRCC ultimately, right? So, on your experience over the past 20 years dealing with visa applications and stuff like that, what are the main reasons for refusal, and what should people do to kind of rectify and see how they can reduce the number of refusals that they
Yeah,
experience?
so it depends on the type of the application. We always say you want to prevent a refusal in the first place. So depending, let's say if we're talking about the context of overseas, for instance, if it's a visitor, there are always three things that they have to address. Genuine visitor, so it's a genuine trip, genuine reason to visit Canada, proof of funds to support the trip, and then the big one, ties
Hmm.
back home. Okay, if it's a work permit, even if somebody received an LMIA, you have to show that you have ties because it's still temporary intent. So you have to show that you're somebody who is likely to abide by the rules and the terms of the visa. Uh, Even though you can apply for permanent residence later on, it's initially just temporary. But most importantly, that you meet the requirements of the job. So, for example, if on the LMIA application somebody asks for 3 years experience, but you only show 1 year experience, most likely you'll be refused. Okay, and then other cases it depends, right? If it's a sponsorship, it's not court, it's IAD, so we're not going to get into it. But even on humanitarians, it really, you have to look at the reasons. But I think the way to try and prevent this is by having a pretty complete application to begin with.
Yeah, sometimes we negligently make silly mistakes in terms of the application, and then we mess it up entirely. So it's
Yeah,
good
but
to.
even if there no, yeah, that's for sure. But even if somebody didn't make a mistake, it can be refused. Look, the courts are bombarded here, so there's a lot of people are appealing, and many times we're very successful.
Ronan, I would like to also ask you. See, you raised a point about how some people present facts and it's not complete, and sometimes that leads to misrepresentation as well, right? And they are often offered a ban to enter Canada, and there's a lot of people who have quite experienced this, maybe for a small misrepresentation, or the magnitude of the misrepresentation might be small or big, and then they get a ban. Is there any way that they can appeal such a case or do something about it?
Yeah, so those misrep cases, as we call them, are very complex cases. So the short answer, yes, but you still have the prescribed time to appeal. And then they're very, very different. Is it something that was malicious and intentional? Is it really an innocent mistake? Is it an innocent mistake supported by evidence that maybe was produced? Because many times they refuse an application if you didn't disclose that you were refused in another country. And sometimes when we look at the application and the notes, we can actually draw, with chronology, that maybe it was mentioned somewhere else, whether on the form or on the submission letter. So you have to look at them very careful. They are complex cases, but definitely they can be challenged. And they're very important, as you mentioned. You get a ban of 5 years. It's serious. It's very serious.
Exactly. That's a lot serious, and perhaps maybe reach out to a lawyer and see how best they can solve it, because it depends case to case, and the analysis or the direction action steps might differ based on cases, right?
Yeah, and with the
Uh,
misrep cases, they usually get afforded, they should, procedural fairness letter. So we always say, contact the lawyer at that time. Don't answer those by yourself. Really don't. It's the
yeah, exactly.
consequences are very serious. So you get 30 days. We can always, or any lawyer can ask for an extension of time, and the PFL, the procedural fairness letter, it's an art, okay? And I really recommend everybody to call lawyers at that time, because we find out that people were afforded that, they had some response, and that's it. So those PFL are very important, because even we have cases that we tell the client in advance, we don't think we're going to get your visa approved, but we'll get the misrep out of the way, and then we're going to refile, do it the proper way. So contact the lawyer right away when you get those procedural fairness letters.
Brilliant. So, Ronan, there's another one more question that I would like to ask, and then we could wrap it up maybe. You see, you said that there is an AI-based system that the kind of processes applications these days due to the volume of applications that are there, and then the level of human touch has reduced over time, and that's something that we believe in. So, do you think sometimes the application that that get refused, there could be like a systematic error for refusal?
So it's about systematic care, but the way we treat them, and we kind of have, and not just us, other lawyers too, we had conversations about it. We kind of doing two applications in one. What we mean by that, we have, when we prepare them, we know that probably Chinook is going to look at them, but it may miss some evidence that we sent, so we have to be ready for federal court. Okay, so that's an art too, but a lot of people now, the way it should be, and many lawyers are doing it, the way we prepare the application, we take into account Chinook, and we know what fields are important for the system, and but we also take into account that when this is reviewed in federal court, you have to look at the totality of the evidence. So look,
Right.
like any other technology, it definitely is a good tool, but in many cases, it has its glitches.
Brilliant. So, the one last question, if you would allow me to, you know, refused applications, we understand that, should be channeled, like you said, through a licensed immigration lawyer, and that would be the best case. So, some people, they believe that they could still do it by themselves, because Canadian visa is quite straightforward. You can open a portal account and just try to apply it all by yourself. Why would you advise somebody choosing a licensed immigration lawyer, especially in terms of a refused application?
Yeah, so first of all, only lawyers can go to court. I suppose you can represent yourself in court, but especially when you overseas, good luck doing this with. And federal court is not like the court you see on TV. The the judge or the Department of Justice, they look at what was submitted and what was before the officer. So even if you forgot something, and you can't come now, oh, here it is, and everything is okay. They look at what the officer had before them, and the threshold, and what is reviewed is very narrow. It's not like people see on TV, and oh yeah, it's I'm gonna add this, and it doesn't work this way. So only lawyers can go to court. And look, federal court is like anything, is an art. You have to know what to review, you have to know what to focus on. So I would definitely, especially refusals, there's no more games, right? So as you said, people can apply on their own, but when it comes to refusals, contact the lawyer right away. There's no doubt about that.
Right, brilliant. So that's about it from my side. That's all the questions that I have. If the audience, if you all have any questions about refusals, rejections, or misrepresentations, misrepresented applications, please do feel free to put them on the comment section so that we can raise it up here and we can see how we can best address it with Ronan here. Um, so, with that being said, do you have any final thoughts about refused applications and how we can take this forward?
Yeah, so as we said, there was that famous movie Karate Kid. Okay, and I
Okay.
think one of the phrases that I remember that the teacher tells the student the best way to win a fight is don't get into a fight. Okay, so I think here the first thing you gotta prepare a complete application. Okay, the application has to stand pretty much when we prepare an application, we think that everything is going to get refused. We're thinking about court. Okay, so it has to be to that standard. That's number one. Number two, refusals do happen. Okay, even if you have a great application, but in Canada, that's why we have court, and I believe in our court system. So that's why the courts are bombarded now. A lot of people challenging decisions. So don't panic. Okay, it's not the end of the world. We can definitely assist you. There's strategies, but everything has to be step by step and done in a very smart way.
Yeah, brilliant. So I see that there's no much questions. Maybe we can conclude the webinar today. Thank you very much, Ronan, for all your thoughts about misrepresentation, refused applications, and rejected applications. Audience, whoever is watching this, and if you have a refused application, if you want to rectify it, a few things were shared. Let me summarize it for you. In short, the summary is that you should get support from someone to kind of see how you can best approach this refused application, because that is very important. Somebody has to be experienced to deal with this, because otherwise there could be you could mess it up a lot further, and then it would be a point of no return. So go to a lawyer, seek assistance, and see how you can correct the application and make it a complete application the next time, to avoid a refusal yet again. And we should understand that, like we discussed in this webinar, that refusals are not something to panic about. Refusals do happen, and it's normal. And all that you have to do is you have to ensure that the next time when you put an application, it's perfect, and try to ensure that there is no misrepresentation made, because misrepresentation is considered quite serious, and it might, I mean, at the end of misrepresentation, you will be handed a ban, and that would lead to serious repercussions where you might not be able to apply to Canada again. So, with that being said, I think we can conclude. We have a little bit of a appreciation post from this viewer here. Thank you very much. Thank you for joining us. We would love to see you all next week. Next month, yet again, when we have another webinar on an interesting topic about immigration. I'll see you all then. Until then, thank you very much. Thank you, Ronen. Thank you for joining us.
Okay, thank you. Thank you,
Thank you.
everybody.
Bye.
Bye, bye, bye.